DeDe, welcome back. Today we're going to talk about probate again. I know over the last few episodes we've covered this topic a little bit, but specifically today we want to talk about how to avoid it, if at all possible. And you're going to share some strategies along those lines. So let's dive in and start back at the beginning. Maybe if people have missed the previous episodes, why why would so many Californians actively try to avoid probate? And what are the risks if they don't try to avoid it?
That's a great question, and we get that asked a lot. And probate in California is the process that we have to go through to determine who your natural heirs are and how they will receive it or who will receive it. So probate is triggered with 184,500 in assets. And it's fair market value. It's not equity. So a home here in California, you'd be hard pressed to find anything under the 184.5. And so that is what you're setting your family up for, is to go through the probate process. It's very long. Currently, in December, we closed a probate matter that had been going on for 5 years.
Oh,
We just closed another probate matter that's been going on for 4 years. And granted, there's various different circumstances as to why
mhm.
beneficiaries are fighting, people are disputing, maybe there's some minors involved, maybe there's, a couple of different minors, and then a guardian ad litem has to be appointed. So, of course, there's various reasons as to why these probates have lasted 4 and 5 years.
Mhm.
But the fact is, if you have a will in California, that does not avoid probate.
Okay.
So, no will, of course, you're going through probate, right? Even with a will, you are going through probate. The difference is that if you have a will, at least your wishes will be somewhat carried out, right?
Mhm.
If it's been done correctly and been properly signed, properly witnessed, then you go through the probate process. You still have to go through it. It has to be court approved. And again, creditors can step in, so your family might not be fighting, but creditors could be fighting. Or maybe you've named charities and, maybe the charity thinks they, had some other oral conversation or the charity is disputing, right?
Mhm.
So creditors, charities, they can dispute in the probate. And then of course your heirs.
Okay.
Um, Depending on how it's been done. Was it done properly? Did you forget heirs? Did you forget some of your children, right? I mean,
Mhm.
and I say that jokingly, you don't forget, but perhaps you don't name them, and you probably have valid reasons why you don't wanna name them, but
Mhm.
you just inadvertently forget them, right? And so, or you don't want them to receive anything, so you think, "Well, if I leave them out, then, they're not gonna receive anything," or maybe they were bad kids, who knows? Whatever the circumstances may be.
Mhm. How does a revocable living trust help people avoid probate in California?
That's a great question. So, as we talked about earlier, a will or no will, you're still going through probate, right? So you still have to have a will, but in addition to the will is the revocable trust, right? So the revocable trust avoids probate if it's done correctly, if it's been funded properly, and the beneficiaries have all been decided and designated. So not all trusts are the same. First of all, I would just want to put that out. I've seen a lot of trusts that are just horribly written and they're going to go through probate. And some of those are, with attorneys that maybe don't practice law in this special area. Some are, that do it yourself online. And guess what? They end up in probate. Hopefully, my clients will not end up in probate. So far, so good. But a revocable trust avoids probate because you are inserting the assets. You're putting your home inside the revocable trust as opposed to being in your own name. So, revocable trust has to have the grantor, which is the owner of the assets. And then it also has the trustee, which, as long as you are alive and of sound mind, you are the trustees. But within your trust, you would appoint successor trustees, and then there are beneficiaries, right? And again, as long as you are alive, the grantor and the trustee is the same beneficiary. It's only when you pass that your future beneficiaries will step in. So by having a fully funded trust, that's how you would avoid probate. And also, appointing or designating who's going to take care of you if you become incapacitated. And again, I always like to add that extra clause that says how you become incapacitated, right? And incapacitation, I'm talking about cognitive issues, right? If I'm starting to have some cognitive issues, do I need to go see a neurologist? Do I need to, meet with a family panel? How is that going to be decided that I'm removed? Because if that's not addressed, again, you end up in probate. So it's not just a one size fits all as far as a revocable trust. Oh, I have a revocable trust. I'm not going through probate. There are
Okay.
issues that will lead you to probate, but a fully, properly executed, drafted, and funded trust will avoid probate.
How do tools like beneficiary designations, payable on death, which we'll refer to as POD accounts, or transfer on death, TOD deeds, come into play in this second strategy?
So this is a different way to pass on assets as opposed to the revocable trust. And there are many times where this is actually very beneficial, right? So for instance, we've had scenarios where we will have maybe three kids that are named in the trust. And maybe one child is, has more money than, needs be, and parents have decided to leave this child out, right? But they want to give them something. So they can just have them pass with a payable on death as a beneficiary, right? Because and maybe it is a checking account or a savings account. Maybe there's a stepchild, maybe it's a blended family, and they want to give a surviving spouse or a stepchild or a half sibling. Maybe they want to have them have their inheritance be received outside of the trust. And like I said before, also, or many times, maybe it's a trustee fee. Maybe someone, instead of giving a trustee fee within the trust, they're just going to leave the checking account to whomever is going to be serving so that the bills can be paid right away if it was a checking account or a savings account. Uh, a brokerage account, and again, that threshold of $100,000, I never like to go beyond that because of triggering probate. So there are times when the beneficiary designation is appropriate. And again, same thing with 401ks and IRAs. You don't put those accounts inside the trust, as we just briefly discussed, but those pass by beneficiary designation. And so while the person is alive, they have full access to their 401k or to their IRA. But then at passing, usually it is the surviving spouse that would be the beneficiary of the 401k, but it doesn't always have to be. Maybe you want to split it up. Maybe it was an inherited IRA and you want to make sure that it's going to follow your bloodline. So you're going to leave half to your spouse and maybe you're going to leave half to your children, right? And if it's a blended family, maybe you only want, your children and not your stepchildren to receive it. So you can also name beneficiary designations for the trust or for a particular person. And I think it's a case by case matter, and it depends on the facts of the family dynamics as to how you should set this up. So I think it can be absolutely beneficial, but not all the time, right? You don't want to leave a 401k to a minor child. You would want that 401k to be for the benefit of the minor child, but you want it to go through the trust because remember, with a revocable trust, you can do asset protection or you can do staging, right? So that they're going to receive 1/3 at 25, 1/3 at 30, and then the balance at 35. But you can't do that with a beneficiary designation. Beneficiary designations are usually all or nothing. Sometimes in life insurance you can kind of extend it out. But again, that's another asset that you want to make sure the beneficiary is the trust so that you have more options within your revocable trust.